All right, so chapter 6, estates and interests. So in particular chapter, this is one chapter that it's, again, one of those simple chapters, but there's that people have a hard time putting their hands around. And what's particularly important is that we have to really understand this part to move on to the next chapter. So not all ownership is equal. Last chapter we talked about ownership, interest, but not all ownership is equal. So it may or may not be able to be passed on to your heirs when you die. It may only be used for specific purposes, or others may possess the rights of that property. Okay, not the interest, but the rights. And there are two major classifications for this. Number one, we have what's called a freehold estate and a leasehold estate. And a freehold estate is basically, well, let's back up on page 74. The amount and kind of ownership interest that a person has in the property is an estate in land. Okay, estates in land are divided into two major classifications. One is a freehold estate, and one is called less than freehold. So, freehold estates are estates for what they call an indeterminable length. You own for a lifetime and can pass it on to your heirs, which means that you can actually own the property forever and ever and ever and ever. They are then broken down into a couple different categories, and these are the ones that are the most recognized in New Jersey. Number one is called a fee simple, which is indefinite and inheritable. Okay, we have a fee determinable, which is indefinite and inheritable. But fee determinable means that there's some determinations with it, conditions along with it, where with fee simple there are no conditions. Fee determinable, there are conditions attached. And then we have what's called a life estate, which ends at the death of somebody. It's based on somebody's life. The leasehold estate, which involves tenants, it is for a period of time and is classified as personal property. We'll get into that more when we get into the leasehold section where we talk about tenancy and all that, which I believe is chapter, yes, it's chapter something. It's coming up in the future. But so for this purpose here, leasehold estates involve tenants and are estates for a period of time. Leaseholds are considered to be personal property, not real property. So fee simple. Simple is the highest type of real estate recognized by law. And that we need to know. So the holder is then entitled to all the rights in the property. All of the rights in the property. On the owner's death, the estate passes to his or her heirs. Fee simple absolute. We'll see these terms being thrown around pretty often. So for example, John Smith conveys the title of 1,000 acres to the Jones Foundation so long as it's maintained as wildlife preservation. That's what we call fee determinable. It's got a condition to it. It's got something that says so long as they do something, then you can have the property. In Collingswood, for example, the park just across the street from the high school was donated by a family who owned that parcel of real estate. So long as it's used as a park, it could be it's dedicated to the town so long as the town remains dry, meaning no alcohol. Now the interesting thing is Collingswood just opened it up and they're now no longer a dry town. So what's going to happen to that? Well, we shall see. But that park was dedicated so long as there's a condition attached to it, yeah, right? Pittman's the same way. Pittman has the same conditions. There's pieces of real estate in town that are dedicated so long as. So a fee determinable has a condition or a defeasible fee is what we call it, a conditional fee or a defeasible fee. An estate terminates on the occurrence or non-occurrence of a specific or specified event. Okay? The possibility of a reverter is future interest. Now, what does that mean? Well, in this case, if it's in there, now it may not be, but we don't know, but if it says in there, so long as the town is dry, this land is yours. And the moment you start to offer alcohol for sale, it then reverts back to me. Now, if I'm dead, this is some 70 years later, if I'm dead, it goes to my estate. And from there, it then could do something else. That's called a reverter when it reverts back. Now, I could also have in there a reversionary interest, but yet I would add somebody else to it, like a remainderman. We call that a remainderman, a third party. So I'm going to give you the property so long as you don't sell alcohol in the town. If you do, then it reverts back to me. But oh, by the way, I don't want it. I'm going to dedicate it to the something foundation, the Cancer Foundation, and then they can determine what they want to do with it. This happened in North Jersey with a college where this gentleman owned lots of acreage, and he dedicated it to the college, and the college went belly up, and they sold it to a corporation for use of building an office building. Well, the property then was reverted back to him, but the guy died, and it went to his estate. Now, there was no remainderman there, but it went back to his estate. You see, so that could be a possibility with what we call fee determinable. Fee determinable. When it comes back to, because of the condition had been terminated, that's called a reverter, and if it goes to somebody else, it could be a remainderman. Got that? Now, the life estate is limited to the life of a specific person. Okay? It cannot pass ownership to its heirs. It ends at the death of the owner, but there could be a reversionary interest that is governed by the conveyance, which means that I'm going to give you a life estate. It's based on your life. You die, the property comes back to me. Okay, that would be called a reversionary interest, just like the just like the reverter in the previous example. Okay, reversionary interest would revert back. Now, also, there could be a remainderman that after this reversionary interest takes place, that I say, okay, well, instead of it coming back to me, I want to give it to my uncle. That would be called remainderman as well. So tied to the life of a third party, which is what they call appertive, and I'm probably saying it wrong because I didn't take French in college or in high school. Pure attreve. Say it right. Yeah, pure attreve, right? Pretty close.
You're close, bro.
Close. I'm close. I'm close.
You're the boss, so you're fine.
I'm the boss and I'm fine. That's right. I took Spanish, but not.
So you making stuff up as you go.
You don't even know, right? You wouldn't even know if I was making it up, right? You're just like, yeah, whatever you say. So that means tied to a third party. It's tied to someone else's life. And then with the life estate, we cannot waste or harm the estate, which means we can't encumber the estate. We can't dispose of it. When they say waste, they mean that you can't sell it. You can't sell the property, right? So, but it may be sold, leased, mortgaged, or given away, which is interesting because you can mortgage it, but you can't waste or harm it. And will end at the death of the person whose life it's measured against. Okay, so the example in the book here on page 75, it says that if Alan specified that Claude received the property on Betty's death, then Claude would be the remainderman. But let me back up and actually read to you the case. For example, Alan gives a life estate to Betty for as long as she lives. Upon Betty's death, the disposition of the property is governed by Alan's original conveyance. If Alan maintained a reversionary interest, the property would revert back to Alan or his heirs. If Alan specified that Claude would receive the property on Betty's death, Claude would be the remainderman. Life estates can also be tied to the life of a third party, which means that Alan could have given the property to Betty's son, Charles, for as long as his mother was alive. Then we would have this thing called, the Charles would then have a life estate, pure attreve, which means on somebody else's life. See, so you can have these clauses built in to this property. Now, I've given my grandmother a life estate at one point because, this happens and this is how it happens. She did not want, she was, at the end of her life and deteriorating very quickly and did not want to go to a nursing home. It was very much, she made it clear her whole life. So I had purchased her property from her, gave her back a life estate, which was based on her life. At the end of her life, the property then transferred to my brother, my middle brother. So there was a reverter and a remainderman all in the same thing. Set up a little differently. It's not something that we would set up. It was something that you would do through an attorney. But at the end of the day, that's how it works. Okay? Yeah, the Playboy estate.
His house with the condition that he'll remain in the
Absolutely. Good point. And that's more of something that happens in today's world. Playboy Mansion, right? Hugh Hefner has a life estate in that property. The guy who bought it, by the way, it's a big story. Did you ever read the whole article about that? The guy who bought it was the guy who lived next door. And he was going to buy that property originally, but didn't. And that property was all in one big estate with all these different mansions on it. So he's going to restore it and bring it back. Although I hear it's going to cost them, close to $200 million to do that. Yeah, he's a billionaire, but I heard it was going to cost him somewhere around $1 million just to clean the grotto out. But bumps. Okay. So in any direction, moving on. Page 75, Dower and Curtsey. We come up against here. Dower and Curtsey. All right. Actually, what you're seeing right now is figure 6.1, which is that little chart to help you through that. Remainderment interest chart 6.2. Okay. Dower and Curtsey. So Dower is the rights a wife has upon her husband's death in real estate he owned during their marriage. Curtsey, on the other hand, is a similar right that the husband retains in the wife's estate. Now, today we don't practice this in New Jersey, but anything prior to 1980, we may see Dower and Curtsey. I haven't seen it in my career, 23 years. I haven't seen that. I don't know if anybody else has seen it. However, there is it's been abolished. So the surviving spouse has the rights of Dower and Curtsey. So any document relating to the property should be both signed by both spouses, no matter which one is the owner. That's the bottom line. Now, when we have the marital residence, if it's a marital residence, they both have to sign anyway, even if it's only in one name. So the property owned by one spouse prior to May 28, 1980 has Dower and Curtsey rights. Documents are signed by both spouses. If it's a family home, all documents must be signed by both spouses. Property acquired after 1980 that is not the family home may be sold by the owner without the spouse's signature, and you really should consult an attorney for that. So if they didn't live in the property as their marital home, signatures. Okay? Oh, what do we got here? We got a pop quiz. All right, slow but pop. All right, so what do we have here? Real property is transferred by what? Indeed it is. Indeed it is. Okay, so again, just going back and refreshing, our pop quizzes are from the previous chapter. Just kind of refresh once in a while to track. All right, so encumbrances. Encumbrance, lien, charge, or liability attached and is binding on real property. It affects or limits the use, the value, and the title. So liens can be both physical liens and they can be monetary liens, right? A lien itself, an encumbrance can be a lien, it can be physical, or it could be a financial attachment called a lien. So a lien, financial claim against the property, we want to highlight that, and then a physical usage encumbrance could be like a restriction, an easement, a license, and or an encroachment. Those will be on the test. So financial claims. Okay, types of liens. So we have financial claim against the property that provides security for the debt or obligation of the property. All right, it could be either a voluntary lien or an involuntary lien. It could be either general or specific. So what a voluntary lien? A mortgage, right? Because you said, yes, I would like to have you put a lien against me or against the property. Involuntary lien is property taxes. Now, we have to understand with property taxes, and when we get into that section, real estate taxes, we'll talk about that the real estate tax is always there. It's a lien that's always there. It's just not enforceable until you don't pay it. So it's a lien that always exists. You can't get rid of that lien. It's always there. Yes, sir.
So sometimes
Mm-hmm.
investors you call, right? You want to sound savvy. They always want to know, any liens against the property? And I always floor them. I said, yes, right? It always is forever and ever and ever.
Right.
And they get all hazard and what have you. But, listen, it is what it is.
Yeah, the taxes are there. They're involuntary. I mean, who wants to pay taxes?
It's always one there.
It's always going to be there, okay? And we'll talk about why that is always there when we get to that section. But the general lien affects all property, money judgments, estate taxes, IRSs. So a general lien affects all property, whereas a specific lien is placed against one parcel of real estate, such as a mortgage, a property tax, a mechanics lien. Now, these liens, financial liens, we then got to then look and see, does it follow the person's property? A mortgage would follow the person and the property, right? It's based on their financial qualifications, but it really is against that property, so it's against the property. Where IRS liens are against the person, but it's a judgment lien that could also be placed against the property, on all properties they own. However, if you have a credit card that you didn't pay and there's a money judgment against you, that's against you, not the real estate, right? Now, if the title company, if they did attach to all your assets, it could be a problem, but it's against you personally. So that's the difference here. Figure 6.3 talks about the specific liens and sort of shows you in a chart how that works. Utility liens against the property, ad valorem lien against the property, mortgage against the property, that special assessment against the property. Figure 6.4, all right, also gives you kind of a look at the general lien description here. Liens attached to the property, not to the owner. So we need to highlight that on page 76 on the right-hand side. Property taxes are specific liens against individual parcels of real estate. Specific liens are illustrated in the figure. General liens include money judgments, federal, federal and state inheritance taxes, debts a person owes, and the IRS. Now the priority of liens is interesting on page 77. Okay, the priority of liens, we'll talk about that in a second. But encumbrance, it runs with the land. It's binding after the sale. Except liens do not survive foreclosure. Liens attach to the property, not to the property owner. So an encumbrance. Under that category, encumbrance, we have liens, and we'll talk about physical or usage encumbrances in just a second. Okay, figure 6.5 sort of shows you here again the order of which liens run. So the way you got to look at it is you got the mortgage lien is in the first position. You got the mechanics lien there. You've got a second mortgage lien. So looking at that chart, which one has priority? The one that was recorded in 1993, right? Okay. So it does also go to say that the priority of liens are determined by how they're recorded. So let's suppose that this 1993 lien was not recorded until, say, March of 1994. Then who would have priority in that lien, in that property? The mechanics lien would, right? Okay. So you have to remember that the priority to which it's recorded. So just because you have it, not everybody records their liens. And I've seen this before where somebody has a private mortgage and they forgot to record it. And now they're begging for, hey, I want my money. And they're like, okay, well, wait a minute. You got this guy over here that's before you that wants his money too. So it creates a problem. So it's important that these liens are recorded at the time of that they were rendered. Except for tax liens, yeah, those take priority. Yeah. Okay, we further go on to say that the effects on title now, mortgage liens, preferred lien, because that's voluntary, right? Second mortgages or home equity loans, construction liens, mechanics liens, retroactive to the date when they were, could also be when the materials were delivered. Okay, so decree by the court, general involuntary lien for the county or docketed. Other counties require local filing enforced through the sale or personal property. So again, to collect on these liens, they would foreclose on the lien, basically is what they call it. And they could demand satisfaction on judgments and enforce through a sheriff's sale. Other types of liens, we have general, involuntary, federal, state taxes, state inheritance tax, debts of the deceased person. This thing called, any questions with that so far? Okay, because that does affect us, right? I mean, the priority of liens. Page 77 bottom, this word called lis pendens. I did get that word right. It's Latin. What it means is notice of a suit. If you're getting, it doesn't matter if it's real estate related, which mostly we see this in real estate, but it could be just a notice that somebody's trying to sue you. That's called a lis pendens. It's the notice, let you know that somebody is trying to sue you or has filed to sue you. When a suit has been filed, it could potentially affect the title to the parcel. Oh, go back one here. Oh, there we go. All right. So a lis pendens is not a lien, and I think that we have to make sure we understand it because, with our environment the way it is now, people not paying their mortgage, getting behind, the banks will file this lis pendens, this notice, and they feel at that moment, oh, I'm being foreclosed on. Well, at that moment, you're not. It's just the notice too. It's just the beginning of. Now, it's an opportunity, I think, as agents, a little sidebar, I think it's an opportunity for agents to get some business that way. You can get that information from websites and things like that, or you can go to the county courthouse and just pull the lis pendens file every month and see who's been filed on and try to reach out to them. So it's an opportunity there for business, should somebody decide to go that direction. But it is not a lien, it is a notice of possible future legal action against the property. It's a cloud on the title until the lawsuit is settled, which is something. So if you have a lis pendens that's filed and you're going to closing, well, that has to be removed in order for it to go forward. Did it?
In Philly,
Okay.
guy never told me.
Yeah.
Right? So, the appraiser goes, he never tells me. It's like, it's going on real time. It's going on real time. It's supposed to close the end of the month. So, the appraiser goes, I give him a lockbox code. And I give him, can't get in. So he's calling me. I'm like, you gotta be kidding me. I gave you the right code. I'm not coming to get you in. I mean, that's what. So I sit back, like you said, I call this guy. I said, what's going on? I was gonna listen up. No, because I know the process. I said, listen. He said, I think the bank changed a lot. I said, listen, slow down. You gotta be like really behind or something.
Right.
So comes clean. But I caught up, and so we're going to get it done.
Yeah, but what happens is it does create a lien on the property. I mean, not a lien, it creates a notice, and the banks will then start to move forward, especially if it's vacant. They go out there and secure the property.
Yeah. The tenant had moved out. Yeah, the tenant. And then listen, he lived in Delaware. The tenant lived there. She wasn't, and he finally got her out and all this. But again, yeah, I mean, it had to happen.
And we have to always ask those questions about are you behind on your mortgage? Because a lot of times they'll say yeah, no, or no, I'm not, and here they are. I've got one over in Chester County right now. It's the same situation. The guy's behind by a lot, like by 12 months, and I'm like, how do you not know you didn't pay? And so we have a problem we have to deal with. But that notice, you can always ask them if they received this lis pendens notice or any type of notice.
Listen, because it's going to show up, so you got to come.
Got to show up. Yeah, it's going to show up. All right, we've got another pop quiz here. So what do we got? Let's see here. Trade fixture is what?
Attached. Personal property that was attached to.
Okay. So you're saying it is, that has been permanently, wow, you guys know this one, right? Must have read. Okay, personal property that has been attached, right? Okay, fantastic. Easements, I'm on page 78. Easements, a right one party to use the land of another party for a particular purpose is called an easement. Okay, that's what it is. The holder of the easement has only the right, not the estate, not an estate or an interest in the property. And there's a couple of ways they can hold this easement, either what they call appertenant, or engross. Okay, now an easement appertenant is where the rights it grants the rights to the owner of the adjacent parcel. Must be two adjacent tracts that are owned by different parties. So you can't own property next door and then give yourself what's called an easement appertenant. There is a servient estate, which is the tract of land over which the easement runs, and the dominant estate is the tract that is to benefit from the easement. If we look at the chart on 6.6, we'll see here that the Lot B and Lot A. Okay, so easements run with the land, and they cease with a semblance of these lots. So if we're looking at the figure 6.6, the owner of Lot B has an easement appertenant across Lot A to gain access to the lake. Lot B is the dominant and Lot A is the servient. The utility company has an easement engross across both properties for the power lines. So, but an easement appertenant is where one is the servient and one is the dominant. B is the dominant because they are taking advantage of the use of that lake. In order to get to that lake, B needs to cross over A's lot. A, who controls the lot, is giving up something. So the servient is the one that's giving up something. Make sense? Could be like a flag lot, yeah, where you need to get on. I mean, like, well, something that's landlocked.
Yeah,
Well-
where you have to access, like I have
Yeah.
one contract sold last year. Serve has a side of his garage, somebody else's front.
Yeah.
Every time he goes through his garage, he's actually crossing over the property.
And what he's doing to do that is what's called easement by necessity. Okay, so an appurtenant is to enjoy an amenity on somebody else's lot. An easement by necessity is when you need to get to your property, and the only way to get there is to cross over your neighbor's lot. That's called an easement. Okay? An easement in gross is a simple right that they have, utility companies. That's the only way to describe it. Power lines, telephone poles. They're not going to keep coming to you and asking you for permission. Comcast, all that. They have an easement in gross. Not going to ask you permission to come and service the power lines or anything like that. It's just they are there, and that's that. But if you're late, if they're late, they pay $20, right? Okay. But an easement by necessity may be required if only access to the parcel is through another's property. So that's a possibility. Now we have a thing here called easement by prescription. It's interesting because it's the use of another person's property or land for a certain period of time. Now in New Jersey, the prospective period is 20 years. This use may or must have been continuous, hostile, adverse to the owner's title, exclusive without the owner's approval, visible and open and notorious. Now, what does that mean? I mean, some people look at this and say, okay, well, the squatter, someone who's squatting in a property, could, after 20 years, go to court and take over that property. I wouldn't necessarily say use the word squatter, but someone perhaps maybe that was in the property. Let's say, for example, that you're renting, or this individual's renting a property that your grandmother owns, and she has allowed them to stay there in the property for 5-6 years. Grandmom dies, she leaves the property by will to you. You live in Chicago and you're not aware of it. The tenant remains there, but they're no longer a tenant. They're not paying for anything. They're living there against the ownership. They're still paying all the utilities and so forth and so on. So then 20 years goes by, right? And now they can go to court and claim this easement by prescription. Now, it's got to be, though, continuous, hostile, adverse to the owner's title, exclusive without the owner's approval. So it can't be where the owner approves of them being there. Because if the owner approves of them being there, then it's not hostile. It's not against the will of the owner. Does that make sense? So there are people, even it could be, let's go, that probably wasn't the best example, but let's suppose there's a tract of land, a piece of land, that perhaps maybe is adjacent to your property. And for the longest time, you mow the grass, you put a fence up there, you put a shed up, and you're using it. And this goes on for 20 years in one day. And yet you don't own the property, you don't pay taxes on it, but you just assumed all of the necessaries. You could at that point, as long as it was against the owner's will or without them knowing, you could apply to the courts for easement by prescription and actually acquire that property. Take it away from the person who owns it. It happens. Now, if there's a break in this, there is a break in the period of time where the owner says, all right, we need you to stop, we need you to remove, and then they have this thing called tacking. It's called tacking. Successive periods may be combined by different parties. So you may be there for 10 of those years, and then somebody else is there for another 10 years. Again, it has to be adverse to the owner's title, exclusive without the owner's approval, visible, open, notorious, things like that. And they can tack on their 10 years plus your 10 years, and they can acquire the property. A little more complicated, but I'm sure it happens. Party walls. Party, right? This is the wall between two buildings. We see this with condos, we see this with townhomes, where you have two walls that are together, and the middle part is what's called the party wall. Usually a little bit over on this side, a little bit over on that side, but the space in between there is owned by both parties equally. We see this in Philadelphia. I mean, just about every place in Philadelphia is like that. We see the townhomes around here. The party wall is the building wall that straddles the boundary lines between the two properties. Each property owner owns one half of the wall. Each owner has an easement right in the other half of the wall, which is interesting. So they have the expenses of maintaining that wall. Okay, this happens a lot with roofs in Philly, especially when you have the roofs there's a party wall there, and they're joining there like this, and they're like, well, I'm not paying for this, I'm not paying for this, and somebody needs a new roof. Okay, now how do we create an easement? Any questions so far? Yeah, this is pretty straight ahead stuff, right? One of the confusing parts is just the easement part, or appurtenant, and then the easement by necessity. Those are the two things that are usually the difficult one here. Commonly created, so creating an easement, it's commonly created by a written agreement. I would say that you really need to have it in a written agreement. It expresses the grant from the owner of the property over which the easement will run. It could also be in the deed, if it's conveyed in a deed. Reserving the easement over the sold land, so the easement would actually go with the property if it's sold. So an easement by necessity, if you need to access your property and you got to come across my property, if I sell the property, it's going to go run with it. Now, it could also be abandoned too. If you then find a way of putting a bridge to get into your property and you don't no longer need my property, that easement can be abandoned by non-use. All right. Also, the easement should be conveyed in writing, long-term usage. Now, something that also happens with an easement, you may have somebody that said, gentleman's agreement. Yeah, just go ahead. Come onto our property to get to your property. Never had anything formally written. And that person dies, and now their family takes over the property, and they're like, yeah, we got to stop this. We're putting up a fence. You can't get to your property anymore. That's one of those things where that expressed agreement between the owners was not in writing. However, if they can prove the party that needs access to the property, if they can prove by going to court that they need this easement, that they've had this easement, that they did this for the last so many years, they could actually go in and get that easement put in place by way of the court. Now, on page 79 top, terminating an easement. Easements may be terminated, for example, when the purpose for which the easement creates merger of the property. In other words, if you buy the neighbor out and you buy the property, the easement goes away because you don't know you don't want to need it. Or release of the right of the owner of the servient tenant or tenement. Or, of course, by abandonment, which is licenses. Well, you're about to get your broker's license, real estate license. It's a privilege. Driver's license, it's a privilege. All right? We need to remember that. That's permission to enter land of another for a specific purpose. That is called a license. It's not permanent, may be withdrawn. Examples would be park in the driveway, put up a billboard, have a garden. These also could be oral agreements, meaning they could be verbal. We could have these agreements by just shaking hands. But they also, they should be in writing. I always say if it's not in writing, it doesn't exist. Because we can have this out of nowhere. Okay, so encroachments. All right. Best way I can describe an encroachment. We see this a lot of times in Pittman, right? You ever sold a house in Pittman where you get down the Grove where the eaves of the houses overlap with everybody else's property because, when they were putting them up, they were using their thumbs to, move it over this way a little bit. The roof hangs over here, so you got a 2-inch encroachment. That's where I first experienced an encroachment. The second place I experienced an encroachment was a shed, a full-on shed in Gibbstown that was on the neighbor's property. It was a garage. It was built brick, the whole 9 yards, and the surveyor came out, and about 3 feet of the garage was on the neighbor's property. As it turns out, this garage, because nobody had fences, the neighbors, it's about right. And then people next door they were friendly with for the whole 30 years or 40 years they were there, didn't bring it up as a problem. But when it came time to sell, it became a problem. Now, how do you take down a block shed? I mean, a garage, bulldozer, or you get permission to have that property encroach, and then of course the title insurance would have to exclude that 2 feet from the policy, and the whole 9 yards. So it becomes a problem. But encroachments are when all or part of a building, fence, or driveway, or any other installation is illegally extending beyond the land of its owner and covers some land of the adjoining property, street, or alley. That's what it's defined as, and discovered, of course, by a physical inspection, mostly by a survey. Because you go out to the house and that property line could just go like this, or so you thought, and really it goes straight because everybody's using their thumb, or maybe they were having too many drinks while they were putting that fence up or building that garage on that weekend. I've seen it happen. Or it could even be a little bit, like an inch. Fence is over too far here. What do you do? Well, you either accept it, deal with it, or you've got to move the fence and or the garage. Okay, long-term encroachments for 20 years or more may give rise to an easement by prescription, however. So, going back to my example in Gibbstown. You see, because that garage was there for probably 25 years, the neighbor could have, by way of prescription, gone to the court and said, okay, we now want that piece where our garage is extending, and take it. So now the property line would go like this, out and around. So that's what could happen. And in this case, it didn't happen that way. They just agreed to keep the shed there, the garage there, and just agreed to accept it through way of a written agreement. But that's what could happen. They could actually, well, now they can't because they've agreed to it, but they could have just gone by prescription and taken that piece of land from them. Okay? And then finally, as we start to come down the wire on this chapter, again, another short chapter, is what we call deed restrictions. Now, deed restrictions we will discuss more in chapter 9, more specifically, but it's added to the deed. They're called restrictive clauses. They're added to the deed when the property is conveyed. Now, a restrictive clause could be something like this. It's established by the seller, and it restricts the future owners from certain use. One of the biggest things with a deed restriction is you could have, I'm conveying my property to you, but you're restricted from drinking alcohol on Sundays in the property. Yes, it happens. Farmers. Boom, 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 boom. Yes, it happens. Where you've got somebody that goes to that extent. Grandfather says to the grandson, I'll convey the property to you so long as you don't bring alcohol into the house. Okay? And then, of course, who's going to enforce it? Well, the enforcement is there's no enforcement police out there. There's not the conveyance and deed restrictive, and so it has to be either a neighbor or a family member or someone who knows about the restriction. It is very possible if the Amish do that.
I'm pretty sure they can be restricted to their children being in the me.
Okay.
Blah, 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 because the way it's charged, the community.
Interesting. I did not know that.
I'm sure that it is. If not, the community takes it back.
Interesting. So the Amish community has, they police themselves with these deed restrictions. That is very interesting. I'm going to have to look into that because I did not know that. And I'm not surprised, but I did not know that. That's very interesting. So we go into more details in Chapter 9 about the deed restrictions because you can add all kinds of things in there. Like, for example, the developer will add, and can't paint the doors red, or you have to use certain windows with certain grades in them. You have to have the panes, certain types of shingles to be used on the roof. So you can have restrictions inside the deed, and that's where we see it a lot of times. All right, any questions at this point? Again, I would say just read through the summary, do the review questions. Again, the big hang-ups where people seem to be having the most problem is the beginning of the chapter, fee simple, fee determinable, life estate. Understand the reversionary interest and the remainderment. Those are like key points. Dower curtsy, not so much because it's just flip off the map, okay? But then we get into the encumbrances where there are questions with regards to that. There's more than one question about general liens, involuntary liens, remember when you get the question on the exam, read it thoroughly. Because and the answers on PSI as well as our exam is the most likely answer. There's going to be two answers that are right. One is more likely right by one word, and one is the red herring, and one is just not even close. There's going to be two answers that don't even make any sense. So make sure you read it carefully and understand conceptually what they're asking you, even if it's underline or when it's on the computer when you take your PSI. Just really think about what they're asking, because those tests are designed to do that for you. Distractors, they're called. All right, any questions? Okay, awesome. Well, we will conclude there.